Good day and welcome to today's Conversation podcast. Today we are privileged to host one of the young lawyers but vibrant, renowned Lusaka lawyer. Is going to comment about a few things in the matters of governance, the rule of law, and just generally what's happening in our country. I'd like to introduce Joseph Chirwa. My dear brother, welcome to today's Conversation podcast.
Thank you, Ambassador. I'm grateful to be here.
Wonderful. You have been making commentary about the Constitution, about the rule of law, and then of course we see you very often represent matters in court. But people may not know who Joseph Chirwa is. Briefly, just tell us who Joseph Chirwa is.
Thank you. As said, I'm Joseph Chirwa. I come from Chipata. I was born in a small town called Petauke in the eastern province of Zambia in 1985. I was raised by my grandparents in a village in Chief Mazimawi's area, a village called Monga village. Then fast forward, I went to Chizongwe Secondary, Chipata Day Secondary. Then I studied my law, and of course, here I am as a lawyer.
Why did you choose and decide to be a lawyer?
My teacher at Chizongwe Technical Secondary School, Mrs. Chawara, I wanted to study medicine, but my teacher, Mrs. Chawara, thought that I'm more of a lawyer or a journalist. So she, we had career guidance those days. She's the one who pushed me to say, either study mass communication at UNZA, or indeed study law. And that's how I ended up studying law. But law is not my first degree. My first degree is in public administration. I have a degree in public administration. Then after I finished my degree in public administration, that's when I studied law.
Okay.
Yes.
Okay. And it's been a passionate journey. Just your professional life, who have you worked with? I noticed now you have your own law firm.
Yes. Yeah. I think my mentors who have mentored me in the practice, first and foremost, is Mr. Tresford Chadi. He's also a Lusaka lawyer. He's the one who mentored me when I was doing my articles at Ziade. Then I worked with the likes of the late Tutwa Ngurube, who taught me a lot of things. I learned how to work on the go.
Yeah.
Yeah. You are never, you can never corner.
Making commentaries about the Constitution, making commentaries about certain articles of the law or certain trends that you think, you do offer your opinion. What inspires you to do that? Yeah,
I think my grandmother used to tell me that I got the knack of writing and reading from my paternal grandfather. So even at school, I used to chair the Writers' Bureau, like a press club. So I think I write a lot, I read a lot, and I can say that biblically those are things they say you have to account for talents. So I think my talent is I like to write. So when I'm seeing things, I always look at how can I communicate. And that's how I've become an author. I think the Law Association of Zambia honored me during the 50th anniversary for the contribution that I've done to the legal profession through writing. So I think it's just in me to write, yes.
Well, it's very good that they recognized your contribution through your opinions that you share through writing. Again, you became very prominent when there were issues to amend the Constitution, Bill 10, and recently there's an issue of lacuna. Now that you dealt with that debate during the Bill 10 proposal, and now that there are these issues around lacuna, what do you think is the state of our Constitution as amended in 1996, or just the state of our constitutional making process so far from 1964?
Yeah, so Zambia has had 3 constitutional changes, constitutional regimes. Our first constitution was in 1964. That's the Constitution of Zambia. of 1964, Appendix number 1 of 1964. Then that constitution was repealed. So there's an issue of amendment. Amendment is where is piecemeal, you are changing things as they go. But where you change the entire constitution and bring in another one. That's what I mean by constitutional change. So the second one, we had it in 1973, which is known as the one-party constitution.
This was a total repeal.
A total repeal of, we had a totally new document from the one we had in 1964, which was called the Independence Constitution. Then we had another change in 1991, which is the constitution we are using now. So we are using Chapter 1 of the Laws of Zambia, which is Act number 1 of 1991. This constitution has seen two changes. There was a change in 1996.
Amendment.
An amendment, not an overhaul, which is known as piecemeal change in constitutional language. So in 1996, under Act number 18 of 1996, we had an amendment, meaning that the constitution of 1991 still stands.
But amended.
Amended in 1996 by Act number 18 of 1996. Then we had an amendment to an amendment in 2016, where we had Act number 2 of 2016. So the constitution we are using is a 1991 constitution, which has two parts, two amendments, so to say. The first part is the general issues, like how do you elect the president, how do you appoint judges. Then the second part is a Bill of Rights, which is part 3. That one, we are still in the amendment of 1996. Yeah. That's the one we are using. So we have a patched, like in our language we say dakanya, like a patch, magamba of the constitution. So the constitution is in disarray, so to say. And I've been consistent on this, that we have, the constitution is in disarray. And the constitution is quite talkative. That's why we have these problems of lacuna. If you look at the Constitution of America, it has stood the test of time almost 500 years. They change. You know, the law is like a clock. It must change with time.
Yeah.
But in Zambia, we make unnecessary changes, which I can say they are not.
You've used words that our constitution is talkative. What do you mean?
I mean, you can't have, for example, have a constitution. I know there are other justifications that other constitutional scholars have brought about. For example, we have the number of MPs in the constitution, meaning that if we want to change, we go to change again. We have the number of ministers. Of course, it says it to be prescribed. That one, it was a clever way of running away. So what I mean is that, for example, we can have an act of parliament to define the number of seats in the parliament. You don't need it to be. Our constitution defines even what a day is, what a child is. Those are necessary things. The constitution is like a foundation. It's a blueprint. A constitution is like a manual. A manual of a car, it will tell you this is how a car is. How to drive, it will not go now, you have to indicate when you reach the traffic lights, you have to do it. No, those are things like it. So a constitution is a blueprint. Because of that talkativeness, that's how now we find ourselves in clever politicians who are going to identify things in order to run away from certain things.
It's been 60 years. Why do you think we haven't achieved a satisfactory constitution?
I attribute that to two things. Actually, that's my PhD dissertation as we speak. I attribute to two things. One, we don't have the will in the courts to give life to the Constitution.
Explain.
What I mean is this. If you're going to go to a court to pose a question to a court, then a court refuses to answer a question, you are promoting the lacuna language. Or if a court gives a decision that is not comprehensive, it leaves room for a gray area. What am I trying to say? Courts, Chief Justice Marshall of the USA stated that a law on its own is irrelevant, it has no life. It is the courts who breathe the life into a constitution, into a law, to give it effect, to give it. Look at Roe versus Wade in America. There's this controversial case that deals with abortion. It changes with time. They are able to change. Now imagine if the issue of abortion was in the US Constitution. How many times would they have changed the Constitution? A number of times. So I attribute that to the will. The courts must have a will. You look at the Constitutional Court of South Africa, the way they've given effect to the South African Constitution. You were the ambassador in South Africa. I don't think you've ever heard South Africa, they want to amend the Constitution. How has it worked? Because the courts there have been magnanimous enough to give life, to give context to a constitution.
Do you think our judiciary is timid to make pronouncements, for example, on board interpretation of the Constitution, or, like you are saying, give the Constitution life instead of rushing to legislators to try to amend the Constitution?
No, I can't say. I know that courts work under a lot of environmental factors, so to say. But also this comes to the will of the people. Yeah. I think if the people in a particular constitution, Zambia basically has a parochial society. A parochial society is where people don't care. As long as they've eaten, they have bread, they have food at home, they don't care. As long as it doesn't affect them, they will tell them, no, that's his own problem. So I may not go into the details of those issues for various reasons, professional reasons, so to say. Yeah. Yeah. But what I'm trying to say is that courts have tried to give effect to the Constitution, and at some points, of course, they have not done so. Because justice is a two-sided coin. The person to whom the decision has gone for, they'll be happy with that context. But what I believe in is that courts have a crucial role to play in giving life to a constitution.
What could be the second issue? Because I posed the question of why we still haven't settled for a constitution, and you've attributed one to the courts. I think they should have given it life. What could be the other?
There will never be a perfect constitution. Okay. And it's the courts to iron the creases that may be found in the constitution. You can never have a perfect constitution. So whether we like it or not, courts have a duty to play. We are talking about the High Court for the purposes of the Bill of Rights and the Supreme Court. You appeal to the Supreme Court. Then we are talking about the Constitutional Court for the purposes of interpretation of the Constitution. The second issue is how the greatest question, one of my lecturers at Disarray is now the Deputy Chief Justice of Zambia, used to tell us, to say, the greatest question usually is why. If you find the why, then you have a best outcome. So the question we must pose ourselves is, why are we amending the Constitution? If it's to amend the Constitution, for example, in 1996, to eliminate a candidate, to eliminate Kenneth Kaunda from contesting, then it will come and bite you. So if we're going to make a constitution for the purposes of self-interest and not futuristic, not being futuristic, we'll be going in circles. We'll be making and remaking and making. It will be a story that will never end. So once we find the why will lead us to how do we adopt this constitution. If the supreme elite of a society, cabinet, as it has always been in the past, they dictate what should be in the constitution, remember, power changes hands. So the new people come, they will not be, they also want to push their agenda. So I think the way we've been adopting the constitution, we must learn. Where have we gone wrong? We've gone wrong because we've adopted the constitution, we've imposed the constitution on people. That's why when people come, they are able to change. And again, we go back to the issue of the courts. Courts must be given powers to be the last, once the people agree on a document, the courts must be the last bastion of interpretation or giving effect to the constitution. Because if we leave it in the hands of human beings, of the people who are contesting for power, the executive and the legislature, will always be going in circles. So the mode of adopting the constitution has been bad. The interest, the why, has always been personal interest. In 1964, we had national interest. We amalgamated as a people because we wanted independence to self-govern. In 1973, we changed the constitution to give one person a life tenure as a life emperor. In 1991, we sat down as a people, we had an amalgamated position. We wanted to go back to multipartism. But what was the reason of changing the constitution in 1996, amending the constitution? What was the reason of amending the constitution in 2016? So you find that we haven't been correct in the way. We've done this a number of times. Mwanakatwe, Mungomba, NCC, a number of times. It's a subject that even at university, myself, where I teach, we don't even allow people to write on constitutional making, because nothing. Munanduru has already spoken. John Sang has spoken. There's nothing more. Professor Nsungura has spoken. There's nothing more we can speak about the constitution. We know the reason why the talk of amending of the constitution will always come.
In 2016, I think following a process that had started under Mwanawasa in 2007, its adoption failed in Parliament in 2010 under Rupia Banda. President Michael Sata picked it up, put up a technical committee that then, by the time President Edgar Lungu is beginning president, there was pressure that we should go to the 2016 general elections with the new constitution that had been worked through. I think President Lungu promised that we were going to have a new constitution. But what we heard was that there was a failure of a referendum, because there was an opportunity to do a comprehensive constitution, but there was a failure of, I think the referendum didn't go through. But in 2016, President Lungu and the various MPs did their part. He signed a new constitution and said the issue of part 3 of the constitution, which deals with human rights, cannot be amended by the people. I think because of that clause, Article 79, that says if you are amending the Bill of Rights, you ought to go to referenda. And if you want to remove that clause again, Article 79 itself,
the double
you also
it's
go
a double
to
entrenchment clause, yes.
Yeah. So President Lungu did his part. The parts that they could amend, I think, and there was a bipartisan approach. It was supported by the UPND, and decided into a new law and deferred the referendum to the new elections that were coming towards the end of 2016. But the referendum failed, but the amendments of the Constitution was done. 3 years later, we had the Bill 10, attempting to amend the Constitution that we had done in 2016. And now you had President Hakainde Hichilema, who was addressing the 4th session of Parliament, the first session of the 13th National Assembly Parliament, and he announced that he was going to effect constitutional amendments. He talked about the famous word now, lacuna or lacune or lacunas. What is your view about these proposed constitutional amendments?
Yeah, so I think the Constitution, we should leave it as it is. Despite it being bad, the way I've said that it's in disarray. Let's leave it. We give powers to the courts to iron out the creases. That's the only way jurisprudence will be refined. I know I support as LAS, I sit as a council member at LAS. We issued a statement as LAS, and we are very categorical, and I stand by that statement. I know the president didn't even mention any article during his address. His people started reading into what he said. I would love to have a chat with the president to say what was the context, because Article 52(6) that people are talking about is settled. I was one of the
a matter of controversy.
I was one of the lawyers. We had an issue. Makebi Zulu, Jonas Zimba, Tutu Angulube. We were defending Bowman Lusambo and Joseph Malanji in the Kabush, and there was a matter that was brought by Peter Sinkamba and Isaac Mwanza versus the Attorney General regarding Article 52(6). Remember,
what were the questions? What interpretation did they want from the
I can't remember the questions, but I remember the obiter dicta in that, sorry, the ratio disdain, the outcome, is that where a person resigns, I cannot, I wish I could read exactly what they said, but an election can be postponed under certain circumstances, which the Constitutional Court dealt with. I wish I had come with that. But
so the matter was settled.
The matter is, there's no way an election can be cancelled indefinitely. It's not envisaged in the constitution of Zambia to cancel an election indefinitely. There's no reason why an election can be cancelled for 8 years. But remember what I said? The why. Because people read the constitution to give, people usually they may read the law. I'll give you an example why we shouldn't read laws in order to favor our interests. In 2021 or 2020, we had a matter concerning Deepak Patel versus the Attorney General. He moved the Constitutional Court to answer questions regarding the borrowing, to say government had borrowed without going to Parliament. I disagree with the outcome of the ruling, because basically what the court ruled was to give a blank check to a government to borrow. Because of that, that's why other people now can sell a mine or can sell a national asset to find a loophole, to say we didn't sell, we only issued whatever. So we shouldn't read the law for the purposes of finding a lacuna. We should read the law for the purposes of giving it effect. What was the intention of the legislature, for example, in Deepak Patel, to say government, the executive should not borrow but go to Parliament? When we have the intention, you will know that the intention was to prevent governments from doing what? Over-borrowing. There's no way the framers of the Constitution could have envisaged where an election, there's a date for elections, there's a term first of all, a term.
So there's a 5-year term defined.
There's a term which is already defined.
And there's an election date defined.
So under circumstances, the postponement will be within. But of course I've heard people say, what if there are 32, in Zambia at one point were 32 candidates. What if there are 32 candidates and the other 30 are sponsored by a particular individual, where this one resigns? Those are issues that the courts can settle. We don't have to go back. And I'm on record. Of course, most people said no because I was a PF sympathizer, hence my position. I was on record that Bill 10 was not entirely bad. Because Bill 10 wanted to address these issues. And I used to sit in meetings where I would identify these issues to say, let's have a proper constitution by addressing these issues. The problem is that the Constitutional Court in Zambia has taken a stand to say it cannot pronounce itself on scenario issues. I was in the case, I went to the Constitutional Court with the Institute of Law, Policy Research and Human Rights versus the Attorney General, where this question, I raised it. For example, my client wanted to raise a question. Is it possible in Zambia to have an independent candidate as president? Then there's a provision in the Constitution that, for example, you have a candidate. This is XYZ party. It has a candidate. A candidate dies. They are given a chance to replace that candidate. But what if it's an... So there are a lot of questions that we posed in that case. We wanted... Because after seeing that Bill 10 had failed, we wanted the court to pronounce itself on it. So it was a replica of almost a lot of things that were in the Bill 10. But the court sent us back. It said we don't answer scenario questions. We are not an advisory court, which is not what I believe in. I've read constitutional law. I'm reading constitutional law at doctorate level. The Constitutional Court is an advisory court. Everywhere else in the world, it is an advisory court. It is a consultative court. Which should even answer scenario questions. Our questions was that we have elections that are coming. These things must be answered. They refused. They said, no, we don't have, we are not an advisory court. We do not answer scenario questions. You can only come here when what they call a cause of action, a factual situation. So,
they do want to do with assumptions or speculations.
It's not even, like what the president said, it's not a speculation. It can come to pass. It's not a speculation. The court must be able to advise, no, this is what it is. But in my view, I stand with the position of the Law Association of Zambia. There is no circumstance under the Constitution which can warrant an indefinite postponement of the Constitution. Yes.
8 years.
Remember that Parliament stands dissolved immediately after a certain time, their term expires.
And what about
and we don't have ministers.
Date of election?
And the law is very clear. Ministers will also vacate office. Ngosa Simbiakula and others. The UPND, they're the ones who sued.
Yes.
Where they said, it's only in Zambia where a president remains without a cabinet. Those are decisions that I disagree with. A cabinet, there must be a time when they hand over. You cannot have a president alone and a vice president without a cabinet. So it's through refining of jurisprudence that we are going to come up with correct positions, through engagement with the courts, unlike changing the constitution. Because trust me, they will change the constitution right now. Most people will say it's a UPND constitution.
Again, if there's a new government,
they will change.
There will be attempts to change the constitution.
So I don't think it's the best way. Bill 10, we can revisit Bill 10. Actually, I'm foreseeing a situation where the law that will be proposed to be amended will be actually a Bill 10.
But morally, it will be very difficult for the UPND because they celebrated when Bill 10 fell. They campaigned heavily that Bill 10 and the so-called lacunas and inadequacies in the Constitution should not pass. Yes. They said the Constitution is a good document. So when they turn around and they want to push Bill 10, it will clearly be a moral issue that now what has changed because it will save your interest.
Exactly.
Yeah.
We shouldn't, the Constitution is a political document. We must agree. It's a political document because politics is about getting what? When? Like you are pushing for power. But at the end of the day, the Constitution is a compromise document, the way they did in South Africa, the way they did in America.
It's always a compromise
document. It's a compromise document. No one wins because it's a people's document. So the UPND now, they agree that we need delimitation. How are they going to delimit without going to change the Constitution? So it will be hypocrisy, as you have said. All of us agree. For example, some of us who work with the people in the communities, the constituency I come from is called Kasenengo constituency. It's almost the size of Lusaka.
And one MP can't serve it.
One MP can't. So...
And there will be need for delimitation.
Yes. But of course the fears...
But the trouble is such issues are vested in the Constitution and require an amendment.
We have to amend. So for us to increase the number of MPs or constituencies, we have to amend.
So in one breath, this is a confusion to our people. In one breath, we are accepting there are issues that require ironing out. And on the other, we are saying, no, don't touch the Constitution. Which one should it be?
Yeah. It comes to, we shouldn't have. If at all we have to learn mistake from our experience, we shouldn't have a talkative document. Do we really need to have the qualifications of the Attorney General in the Constitution? Do we really need to have the qualifications of a judge in the Constitution? No, sir, we don't. What if the population grows? Then we have a limited number of lawyers who are 10 years and above. For example, in China, they are suffering from what they call the population boom, right? Where they have old people. There's a gap, even in Japan. So what if we reach a stage where a lot of lawyers, 75% of lawyers are those below 10. Only 25 are those above 10, and others are not even willing to take up positions. You see the danger? We have to go and change the Constitution. There will be a need for more judges. So in other countries, these are things that can be addressed through an act of parliament. I know for issue of, I was speaking to one UPND MP who is a colleague of mine, who is a lawyer. He said the fears of the UPND was what they call in America gerrymandering, where you create constituencies in order. So for example, if the UPND has a stronghold in Southern Province, they will create more constituencies so that they have numbers in parliament. If the PF is strong in Eastern Province or in Luapula, they will create. But those are unfounded fears. That they need to be controlled. You can have a board where those things have to be approved. And this goes to the powers that the President of Zambia has. The President of Zambia has a lot of powers. There's no separation of powers. Strictly speaking, in Zambia, it's not possible.
The president has a lot of powers.
The president is the emperor in Zambia. The president, from 1964, we have given one man, one woman a lot of powers. So much that there's no, yes.
You know, when we discuss currently the shrinking of democratic space in Zambia, it's being attributed to the president who seems to have overarching influence on Parliament, on the Judiciary, on Electoral Commission of Zambia, and other institutions. So it comes down to what you are saying. The president is extremely central. He's like an emperor, like you are saying.
Yes, the president in Zambia has a lot of powers. Imagine in America what happened in 2022, the last time they had elections, 2020?
In 2020.
Yes. Imagine if the Electoral Commission in Zambia, in America, was ruled by the president, then Trump, who did want to hand over power. What would have happened? In South Africa, we learned Umukonto Wesizwe. They wanted to suppress Umukonto Wesizwe, the ANC. They even went to the Constitutional Court to have it registered. But because of the strength of the institutions there, Umukonto Wesizwe is now the official opposition in South Africa. So, everywhere in this world where a president has a lot of powers, I can give examples. Uganda, you've seen how the constitution has been mutilated. The best constitution. Zimbabwe, you can see where the constitution is. Everywhere in this world, you cannot give one person. If men were angels, there would be no need for government. That's what we learn in administrative law.
Repeat that.
If men were angels, there would be no need for government. The fact that we are not angels, we are fallible beings. That's why we have governments. And we have governments, according to Montesquieu, we have this separation of powers for the purposes of checking each other. Checking each other. Even a husband at home, he can provide, but he will be scared to go home at whatever time. Because the separation of power. Someone will question, why are you coming at 01? Where were you? That's what we need. And we've agreed in all the submissions in Zambia for constitutional review, we've agreed that the Zambian president has a lot of powers. And unfortunately, where the president sees a lacuna, it will be a lacuna. Because of those powers.
Yeah, correct,
yes.
Correct. You had written an article that had excited the legal fraternity about the Forfeiture of Proceeds Act, I think, of 2010, and I think the amendment that was done to the Anti-Corruption Commission of 2012. These are dealing with rights of citizens where law enforcement agencies have been empowered by these laws to seize goods and assets that citizens own. Just under the view or reasonable suspicion, an officer from the ACC or DEC can seize your car, can seize your house, can seize any of your property, can close your bank account under his discretion. In some cases, there is even a prosecution that can be done without establishing the crime, and your assets can be obtained or taken away or forfeited to the state. These two laws, the Forfeiture of Proceeds Crime Act of 2010 and the amendment that was done to the ACC in 2012, you wrote this long article. What were you trying to say?
Yeah, so I titled that article, if I remember, The Tyranny of Good Intentions. The tyranny of good intentions.
Yeah, now explain.
So, the tyranny of good intentions. There's a book I bought some time back in 2007 when I was doing I wanted to do my master's. So, the tyranny of good intentions, that book talks about how we make laws for good intentions without paying attention to the fact that these laws are inherently bad.
Okay.
So the good intentions, probably the movers of the forfeiture of proceeds, they had good intentions to say we must recover the loot that has been
proceeds of crime.
Proceeds of crime, we grab them back for the benefit of the people. Good intentions, because all of us don't want our leaders to be stealing from us. But what is a tyranny about that issue is that it has been abused. We are at the mercy of law enforcement, who can even move right now and say that suit that you are wearing is suspected to be stolen. Before I'm even convicted of stealing, they use what they are calling now civil forfeiture. Very bad law, very outrageous, unconstitutional, and bad law.
Explain, why is it a bad law?
To me, it's Article 18 is very clear. I know what the courts have ruled, but I disagree because I have a right. So, as a lawyer, I'm only obliged to respect the courts, but I'm not obliged to agree with the courts. I can use it as an authority, but I'm not obliged to agree that because the courts have pronounced, I should agree with it. No, it will bind me in my day-to-day life, but I have a freedom not to agree with it.
So what does Article 18
Article
of the
18 is
Constitution?
very simple. It comes from the Bible. I mean, Adam had eaten a fruit. God called him, Adam, where are you? He was subjected to due process, in short.
Or God just didn't punish
No,
him?
no, he didn't just, and that's how I start the article. He called Adam, where are you? What have you done? Adam tried to pass the blame to say, no, it was this woman you gave me. But at the end of the day, after being subjected to due process, where he gave his evidence, I'm sure there was examination in chief, cross-examination and re-examination. Adam was found guilty of having eaten a forbidden fruit. Didn't I tell you not to eat this? Yes. It doesn't matter how you ate it, but the fact that you did what? You ate. So, Article 18, that's the premise that we are all innocent until proven guilt. But what FOPA does, which I call a freedom of, the forfeiture of proceeds. The FOPA, what it does is that it reverses. You are innocent, you are guilty until proven innocent. It's unconstitutional, outrageous. I know there are decisions that have tried to justify that law. That's an outrageous law that has been discarded. In the same book I'm talking about, Tyrant of Good Intentions, the man talks about that law, how it started in America and how the Supreme Court of America found it unconstitutional.
So the law we enacted in 2010, where it gives discretion to law enforcement agencies under their reasonable suspicion to get properties from you and declare them proceeds of crime, even before they establish what crime has been done.
Exactly.
Has been repealed in America.
It was discarded. Even in England, it has been discarded. Of course, there they will seize your properties, they will subject you to due process. Then once they find you guilty, they will move in for your properties. That's the way. That's a common sense.
In fact, before 2010, the way the law provided for was at first they needed to convict you of a criminal offense before your assets could be. So they needed to prove that these assets are stolen before they could seize those assets from you.
I must have participated in a corrupt transaction for me to buy my car. You cannot get my car because you are suspecting. There must be what is known as a predicate offense. And that's what the Court of Appeal, I think we have two decisions in Zambia. The Court of Appeal has ruled like that. But I was shocked to learn that the High Court departed, in inverted commas, more like castigating the higher court for that position. The Economic and Financial Crimes Court, in one of the decisions, I'll not go into detail. But
no, that's very important for our people.
Yes.
Because there was an appeal that went to a court of appeal. Because in Zambia, we have, of course, from
we have a court, of courts,
magistrate, high court, and the various courts that are equal to the high court. And then you have the appeals court, the court of appeal. Then you have the Supreme Court on one side, and you have the Constitutional Court on the other. So recently, the Court of Appeal literally said that law was illegal to some extent.
Yes, it is an illegal. Common sense. Common sense. For example, we have a case of Austin Riado versus the people. We have a High Court decision and the Supreme Court decision. I agree with the High Court decision. I disagree with the Supreme Court decision. The moment you grab my things before I'm even convicted, I'm even found guilty, what message are you trying to say? You're saying I'm guilty. Then my appearance in court is a charade. So the normal procedure across the world, look at the best practices in France, everywhere across the world, is I'm convicted of an offense, then the prosecutor are given, they have a burden to tie my properties to that offense. Because not every offense, for example, I'm involved in causing death by dangerous driving. It has no connection with me buying a plot. So you must establish that an offense was committed. And there's a reasonable belief okay, that, because it's not on beyond reasonable doubt, because beyond reasonable doubt was already established, it was already utilized when I was being convicted. But the balance there is lower. You are simply tying the crime to the offense. So they've made these laws very complicated, but these laws will bite people who enforce them. The way the freedom of, I was doing an article on freedom of information. That's why I'm, yeah. But the way the law, if you look, that's why I remember what I said, the why. Why did MMD or PF enact the forfeiture? When these laws, when you have bad intentions, they always come back. For example, I was telling my colleagues in 2021, before we lost elections, I was telling my colleagues that this cyber crimes law should never see light in a civilized world.
So the Cyber Security and Cyber Crimes Act of 2021, you condemned it?
I'm on record, even sitting, I'm on record.
What did you find wrong with that law?
Look now how it has been, how it has now, it has transformed. It is becoming now a dangerous, it was a small, it's like you are raising a cub. It is now a full-grown lion. Now, I was listening to one spokesperson, a government spokesperson, who was saying, if you're an administrator
of any
WhatsApp group and someone posts things that will be found to be wanting, even you are gone. Was that the intention of that law?
No.
So the danger with some of these laws is that they metamorphosize into something unintended because of the bad intentions, the tyrant of good intentions of human beings.
And President Hakainde Hichilema, in his address to the same session of Parliament we're talking about, has promised even tighter laws around cyber crimes and cyber security. He says they're even bringing an amendment to tighten. And, you know, he says you just can't issue hate speech or tribal remarks or post things under an anonymous article and you think you can get away with it. So the noose is coming very hard. And maybe you can tie it to the Freedom of Information Bill that you've been, Act that you've been working on.
Yeah. There's no Freedom of Information Act, so to say. In the
Access to Information Act.
The Access to Information Act is a shell. There's nothing substantial that it provides. Let's get it the way it was presented in 2002 by Mwanawasa, then by the Mwanawasa government. No government has had the appetite to pass that law. I know in Kenya it was passed. A few months later, they repealed it. Because
so what's the difference with the Freedom of Information Bill presented to Parliament in 2002? I remember that it was presented at the same time as a creation of first ZMBC Act to provide for licensing fees and to take away some of the powers they had and to create also IBA. Some of the powers from ZMBC were taken to IBA. Then there was this ambition to provide for access to information. There was that Freedom of Information Bill. What's the difference with that law in 2002 and the one that was passed by recently?
Yeah, first I would like to maybe the government, for the gesture of even bringing even a watered version of the act into life, I think that's commendable.
Okay.
They've shown the cajon that other people, the previous, how many governments have we had?
Yeah, 3.
Yes, that they've failed to do. The difference is that the bill of 2002 gives powers to citizens. You need information. For example, today I can walk into ACC, ask them, how many people have you convicted? What they're supposed to give me. I can walk into Ministry of Mines. Can you tell me how this mine was sold? Who are the shareholders? How much money was released? You and me don't even know how much that thing. Me, I only read in the paper. I don't have the official position, for example, how much the mine was sold, what. So the Access to Information Act, a bill of 2002, was more, it had a lot of provisions that gave you and me powers to hold our, in the nutshell or in the final analysis, to hold government to power, to give us the information as and when we need it. The one that is in effect has a lot of safeguards, safety valves. For you to get that information, for example, I'm a board chairman of some organization. We wrote to prisons simply to give us the number, or we wrote to the Inspector General of Police to give us the number of people who have been detained in police without being taken to court within the prescribed 24 hours. They told us, no, we don't have such people. Meanwhile, my friends who are politicians that I represent, I can even point.
2 weeks.
Yes. So even then, I used to have friends, even from the other side, like, friends who are held 38 days in what? But when you go to the police, they will tell you, no. Why? Because they are not obligated to do that. So the difference in the final analysis is that the bill of 2002 had given citizens a lot of powers, because information is power. Once you have information, in Kenya, you know, they have a system where there's an app. I have a friend of mine from Kenya. He has an app. They call it e-government. If he is able to tell me, he was able to show me how many pills of Panadol, tablets of Panadol, have moved from a particular hospital, because he's a taxpayer.
Wow.
So he is able to tell at the end of the day how much the equivalent of Ratsa, for example, has raised as income. How much targets have generated. We have targets, which are now, they will be clocking, I think, we are now in 7 years. We don't even know how much. We wait until we are told. But that system, e-government, they are being given in real time, is able to tell, oh, Katuba target as how many these vehicles have passed, this is how much they've done. That's information, power, so that you are able to account to say, why is this road not done when we collected so much? So that's the difference. So even these laws of forfeiture, they are bad laws. Because other people have used it. I'm not only restricting this conversation to the current government, even the previous government, for which I had friends. These laws were being used, some of these laws were being used to stifle, to narrow the maneuvers, political maneuvers of opponents. But that's not the intention of the people to have those laws. That's why we need a strong judiciary, we need strong oversight institutions, such as the Human Rights Commission. In South Africa, the equivalent of the Human Rights Commission, the Human Rights Commission in Zambia is just on the book, where you even have a commissioner who is saying, no, Sean Tembo should have been arrested. They should even keep him longer. That's a commissioner of Human Rights Commission, even saying, no, Sean Tembo should have been kept even more days. You see how it is. In South Africa, your position, in England, your position, by that comment, your position is unattainable. You have to resign.
Yeah.
So we need to strengthen oversight institutions. They are called independent in the Constitution. That's what they are called, independent commissions with the public protector, which is a shell of an institution.
Oh, I witnessed the Office of the Public Protector in South Africa bring to account President Jacob Zuma. Parliament had investigated the issues of Nkandla, where, because the president is a very traditional man and he would spend a lot of time at his homestead in Nkandla in Durban. In the end, the security were worried about the security, and they upgraded, the entire facility from gates to furnishings in the home. And in the end, it's like taxpayers' money was used for opulence. We have similar issues here where President Hakainde Hichilema lives at a private house, and the state is obliged to secure him. So you've seen they've done a new road, they've done new power lines to his house, probably even new water, there are helipads, and the place is secured. But those are issues that attract, interest, for example, from Parliament. And Parliament tried to make President Jacob Zuma account, and they couldn't. The public protector moved in, did our own investigations, and caused the publication of a document that literally started seeing the downfall of President Jacob Zuma. We have the public protector, and like you were saying, Seychelles here.
Yeah, the public protector, I think even the Lusaka City Council is even more powerful than the public protector in Zambia. I know Professor Turisire Madonsera, she visited 2018, she was a keynote speaker at the Law Association of Zambia conference. She's a board woman.
Yeah, Madonsela, for our viewers,
yes,
was a public protector in South Africa,
yes,
to the matters I'm talking to.
And she literally brought down the Zuma presidency. Because we all know the issues of Nkandla, based on Tuli Madonsela's works. Yes. So they are called independent commissions. We have independent commissions. We've got the public protector. We've got anti-corruption commission. But again, remember what I told, separation of powers. In South Africa, they are called Section 9 institutions. Is it Chapter 9 institutions?
Yes.
Even to remove a public protector, a president cannot just wake up in South Africa to remove. But in Zambia, because of the powers, remember that the public protector is appointed by the president. But we have to go now to the tenure, security of tenure of these institutions. That's why we find it very fashionable in Zambia that a DPP is removed by every new president. Tomorrow, if I'm president, I'm bringing in a new DPP. That's a fact.
And it should not be.
It should not be the case. The only position in the whole world where it's acceptable they live with a president is Attorney General. Because that's like a private lawyer. So you cannot inherit a lawyer, someone's lawyer, to be your lawyer. So even in America, it's normal. Attorney General goes with the president. Attorney General actually is the way the president appoints ministers, that's the way the president appoints Attorney General everywhere in the world. Because even in England, for example, Attorney General is a cabinet member, is more of a politician. It's an MP who is appointed as Attorney General. But when you look at institutions of Director General SEC, you saw the drama that is, I will not comment, these are matters that are in court, but there's drama. The appointment of the Director General at SEC, appointment of Director General at DEC. What will stop me if I'm president to bring the entire Kasenengwa boys to take up those positions? So we need to look at the security of tenure. We can only strengthen these institutions if the appointments are on merit. You cannot appoint people to see these positions where Parliament, for example, Parliament has refused, but because Parliament is a game of numbers. It's a party that has majority that calls the day. So whether they don't like me, as long as you, sir, as the president, you want me, I'll go. Then security of tenure. These people must be able to investigate. You know that in South Africa, the Hawks investigates a sitting president. I don't know whether in Zambia it has ever happened where a sitting president, where SEC, you have been in government, where SEC or DEC can have a file, an active file against the president. It's not possible. No. That's why when the president leaves, it becomes like witch hunt. So these are issues. We strengthen these institutions so that if you're going to accuse me, you are going to accuse me. For example, President Banda told me to his face that oil thing, when he heard about it, he is the one who instructed the CC. I was having lunch with him, he told me. I was seated with Amon Jerry, he told me. I instructed DEC. I need my name to SEC, DEC, I called them. Not really instruct, but I encourage them. Because when you see instruct, it means you are interfering. This matter has to be sorted. Remember that it was used against President Banda in the elections, and he ended up losing the elections.
And subsequently,
he was acquitted.
To prosecute him on the same issue.
Yes. So these are issues where these institutions must be strengthened. So that if President Emmanuel Mwamba is being accused of doing what, they are able to move in. Parapara, you know the Parapara issue? Yes.
For Chirwa,
yes.
Where the president lost millions of dollars at his farm and issues arose. What's a president doing with millions of dollars at his farm?
Yes, it became a Cashgate scandal. The Hawks had to move in. He was interrogated, interviewed. They issued a report. Said, no, they were selling cows. And of course, other people do not buy. But at least there's a perception that no one is above.
An investigation was
no
done.
one is above the law.
And the president was summoned.
Yes, Trump was impeached twice as a sitting president. Bill Clinton, the same. So we need to have, right now in the UK, the Prime Minister is being, you talked about security. The Prime Minister is being investigated that he received suits from,
suits.
Yes. Then also that he goes, he's an Arsenal fan. So when he goes to watch, they have no problems about him going to watch Arsenal games. The problem they have is that who is going to pay for his security whilst he's watching a game is in his individual capacity, because that's not the work of a prime minister. So those are issues. Boris Johnson, he was summoned, even had to resign for having parties during the COVID. So we need institutions that can account so that when a president leaves office, he's left to retire in peace and not followed because institutions can't do the work now. Yes.
There's a perception that dictatorship in the country is emerging, that there's democratic and shrinking media space in the country, that there's abuse of human rights. You've seen the US report, the 2022 report was very scathing on the abuse of human rights in Zambia. And there have been others, including Human Rights Watch. But recently, the United Nations also spoke about these, and they stated that Zambia was on the spot for abusing human rights and shrinking democratic space. The counterbalance is that institutions such as LAS, I know you may not speak for LAS, but the church and other stakeholders are quiet while these infringements are going on of human rights abuse against citizens, against political opponents, and even just a wanton abuse of the law and the breaking of the Constitution. What are your views about that?
Yeah, of course, I cannot speak for LAS, but I can defend LAS. LAS has issued a statement to that if silence can make you an accomplice. I don't know how that saying is. Okay? And Che Guevara said, if you do not tremble with indignation at the sight of injustice, then you are no comrade of mine. My wife always asks me why I represent politicians even when they don't pay me.
Why do you do that? Sometimes
I subject myself to people following me, people threatening me for representing politicians. I cannot stand a human being being abused for nothing. I just fail to do that. Even when in PF, there are those guys who are jailed in connection with a treason together with a sitting president. I was representing some of those people. And my colleagues in PF were very unhappy with me to say, why are you doing such a thing? So there's a greater call to justice for being a lawyer than to make money. And these are some of the things that lawyers, courageous lawyers, such as Edward Jack Shamwana, Mundia, Sikatana, Levi Mwanawasa. I know people don't know that, for example, President Lungu, Edgar Lungu, was a lawyer for the citizenship case for Kaunda, challenging the state to expel Kaunda. Those are causes.
I know President Lungu defended the families from the Gabon disaster.
Yes.
And it was a long case for many years.
Yes. Yeah. So sometimes there's more to making money. Of course, we have families. I always tell my friends that my services are for sale, but my conscience is not for sale. I have a conscience. A lawyer has a conscience. A lawyer comes from a community. You cannot see colleagues being detained 14 days for posting a Facebook, a meme of that makes fun of the powers that be. Yeah, so LAS has been very categorical. LAS, I think it has done, it has come up when it has been needed by the people in pursuant of his objectives under Section 4. Of course, the president of LAS is a person who can speak as to what LAS has done, but this is what I've seen. The church, I think the Catholics have been very consistent. The Catholics, through and through, they've been consistent on what they believe in. Of course, other churches, I know that the Catholics are part of the Oasis Forum, the Catholic bishops, Evangelical Fellowship. There are those organizations that speak. A wrong is a wrong. But of course, other churches, they are quiet. They say they don't play politics. But to speak on behalf of humanity is not playing politics. You cannot sit and watch. For example, what is happening in Israel, other people are just trying to say because Israel is I don't know who told them that it's a chosen, they were chosen. I always talk to my pastor, Lucky Cheta, I was asking him, so you mean God has allowed what I'm seeing on TV? So these are issues of where, whether as a church, whether as a lawyer, we cannot continue to be a parochial society. Remember what I said? As long as I've eaten, and because we're scared, we're coward citizenship at sometimes, most of the times. That's why some of these things people just sit and watch. They cannot comment. Even when you put a status, people have the guts to come into my status, for example, to tell you, basakumanga. For me to post something, basanimanga. Now, because of that mentality, basakumanga, that's why we allowed UNIP to be in power for 27 years. Because of that mentality. So we cannot say we are peaceful, what do we say in English? The way it came in Bemba. In Bemba, come back kushishit, eh? We cannot use that saying that no, Zambians are good people. There's no a good person who is a shishited person. So, what you said is correct. All of us, we have a duty to hold our leaders to account. We must provide constructive criticism. We must call a spade a spade. Then there are politicians. Politicians are allowed. It's part of politics. That's why in other countries there are no offenses such as sedition. There's no such thing. In America, they have treason. Treason has never been invoked in a long time, unless it is what they call high treason. The laws of sedition are never, they are not in England where we borrowed. They are not there. Because politics is about what we call abracadabra. Okay? The animal farm, if people are familiar with animal farm, there's a character there who is able to turn black into white and vice versa. They used to call him Snowball. The people who are...
The George Orwell
Yes,
book.
George Orwell, yes, the animal farm. People who are familiar with the politics of the Third Reich in Germany. We have a man called Joseph Goebbels. His job was propaganda. Propaganda is part of politics. Propaganda is part of politics because this is where you are. Politics about competing ideas. Article 60 of the Constitution. You are competing ideas. But who decides what is good to say and what is not good to say? Who decides? Surely a politician cannot decide what another politician should say. Because it's part of politics. Imagine in America, Donald Trump calls the sitting president Sleepy Joe. Because he believes that Joe Biden is asleep. He doesn't even know what day it is. A crooked Hillary. I know
it's part of freedom of expression.
It's part of freedom of expression. And we've fought for this freedom for a long time. And I know it's not always the intention of politicians to stifle the freedom of expression, but the tyrant of good intentions. You come up with a law to regulate how people speak, then others, what we used to call in the Bible, zealots, they will go further now to manipulate the law to kill the intention of that particular law. Yes. So this is the danger that we have.
Oh, wonderful. Joseph Chirwa, a renowned Lusaka lawyer. I'm glad, I don't know when you are finishing your PhD, but we enjoy those scholarly articles you do and your public discourse, and we are very happy that you took time to come and be with us. What are your last words?
My last words are that Zambia is a democracy, a constitutional democracy. And as citizens, we must be able to rise to the occasion. Let's not leave politics to the way we've said that politics is a dirty game. The reason is that there's a danger. If we're going to stay away from politics, especially the educated youth, they're in majority. We're in majority as, I'm no longer a youth, I'm 39, so I'm no longer a youth. Yeah, so, but the young ones, I can say the young people. We have a president who is my age mate, I think, in France. Kaunda was president when he was 40-something.
When he was 40.
We must rise to the occasion. As youths, we need those academics, we need those educated youths to come to politics. For a long time, we've left politics for what I call dunderheads. We've left politics. And the danger is that once we leave it to the ignorant, even the nation is the one that will suffer. We sharpen the nation. Young people, educated people, everyone, they must rise to the occasion. And 2026 is our time for young people. By young people, I mean those below 50. We must strive for political office so that we change the discourse of this country. We debate issues.
What is the current discourse of this country?
The current discourse of this country is blame game. PF was blaming MMD. MMD was blaming UNIP. UPND, every time they want to speak, they will say it's a government, the previous government. Why? We should change that game. And again, the issue of, as long as it doesn't concern me, for example, a law that requires people to be monitored, what they post on the WhatsApp, affects all of us. We must have a conversation. Where there are those provisions where we can petition Parliament to block some of these laws, because politicians were elected to save us. But the narrative is that politicians are our bosses. No. So to borrow what the president of Zambia, Mr. Hakainde Hichilema, said, he said servant leadership. Servant leadership means that the people who are elected are servants of the masses. It's us who hire and fire. We shouldn't wait to say, no, 2026, we vote. We must contribute to the narrative of the country so that politicians, we come up with solutions. We challenge them. If they say done, where are the energy experts right now? I have friends, I was castigating my friends who have degrees. I have a friend of mine is even doing a PhD in physics. I don't know what he calls it. Something where I even look at the board, I can't even see a number because me, I'm a lawyer, I'm bad with numbers. We need those things. You come and we need people. Even the opposition, there's a budget that was presented, or I don't know whether it has been presented. We need to have a situation where the opposition should bring an alternative budget. We need to have shadow cabinets where we know that if PF, for example, will come back to power, Mr. Emmanuel Mwamba will be this. That's what we need, so that we have the confidence in. So the opposition, they must rise to the challenge. The ruling party, they must rise to the challenge. The youth have been sleeping. The only youths who are productive to this country are the Kaunda youths. The rest of the youths that followed those youths, because Kaunda was a youth when he started his work.
The last elections in 2021, the youths were credited to have caused, to have been at the heart of the change that took place. So they did participate.
Just by voting, then they go and pack their voters' cards and wait for the next election. That's not what we want. We need the youths that participate in the day-to-day. Not you just see some youths, no, that one doesn't listen. Oh, no, this youth is just cantankerous. No. Bring your voice to the table. We speak. We can't be cowards. We've been cowards for a long time. Youths shouldn't be cowards. The only youths that were productive, as I was saying, were the Kaunda youths. After that, we are the youths of, they just know how to comply. They live by the day. As long as I have a BMW, they can go to these fancy clubs and drink. That's all. And what has it brought us? Here we are. We can't even have a solution to end a power crisis. Yes.
Oh, wonderful. Thank you very much for coming. I'd like to thank you for sparing an opportunity. You are very busy today. You were in court and you were attending a funeral, but you found time to come and be with us and, share this wonderful discourse. To our dear viewers, thank you for being with us. We're featuring Honorable Joseph Chirwa, one of young and vibrant, renowned lawyers in Lusaka. He makes public comments, especially on the issues of the constitution and governance issues, and he has done a lot of write-ups in relation just to the law and the state of our country. Until we have another guest, good day and shalom, shalom. God bless Zambia.
Thank you.
Thank you.